Go right ahead.
All right. Welcome to the monthly webcast presented by Pro Bono Partnership of Atlanta. We want to begin by thanking Georgia Legal Services for hosting this webcast and making it available on its website. Please note that the information provided during this webcast does not constitute specific legal advice and is for informational purposes only. My name is Jill Gerardo. I'm in the Atlanta office of Womble Carlisle, and I will be talking today about HIPAA. Keep going.
Okay, hold on.
Okay. Or I can just move.
Yeah, or she said you move to the left. It doesn't matter. It's up to you.
I move to my left?
Yeah, to you. Oh, actually the other way. I'm sorry, my left. Sorry.
That's okay.
Let's see. That looks. How's that? Okay, thank you. And she sounds good too? Perfect. Thank you. Okay, you're good.
All right.
Let me stop recording.
Welcome to the monthly webcast presented by Pro Bono Partnership of Atlanta. We want to begin by thanking Georgia Legal Services for hosting this webcast and making it available on its website. The information provided during this webcast does not constitute specific legal advice and is for informational purposes only. My name is Jill Gerardo. I'm in the Atlanta office of Womble Carlisle, and I will be talking today about HIPAA considerations for small nonprofits. As you'll see, slides 2 and 3 give you more information about Pro Bono Partnership of Atlanta. The mission of Pro Bono Partnership of Atlanta is to provide free legal assistance to community-based nonprofits that serve low-income or disadvantaged individuals. Pro Bono Partnership of Atlanta matches eligible organizations with volunteer lawyers from the leading corporations and law firms in Atlanta who can assist nonprofits with their business law matters. For more information about becoming a client of Pro Bono Partnership of Atlanta, please take a look at slide 3. I'll move on to slide 4 now, an introduction to HIPAA. HIPAA is the Federal Health Insurance Portability and Accountability Act of 1996 and the implementing regulations issued by the U.S. Department of Health and Human Services. Throughout the webcast, I will refer to the U.S. Department of Health and Human Services as HHS, so I just wanted to point that out. Keep in mind, HIPAA is a federal law, but entities that are required to comply with HIPAA also have to comply with applicable state law. So then you get to the fun question of who must comply with HIPAA. HIPAA originally applied to 3 types of entities. We call these entities covered entities. Covered entities is a term we'll use throughout the webcast, so I wanted to focus on it for just a few minutes here in slide 5. Covered entities are the following: health plans. Examples of health plans are Medicare, Medicaid, at your group health insurance plan at your place of employment. Any plan that pays for the cost of medical care is a health plan, and they are covered entities subject to HIPAA. Another type of covered entity is a healthcare clearinghouse. These are entities that process and facilitate the processing of certain information from one format into another to submit to health insurance companies or submit back to providers. I can provide more information on healthcare clearinghouses if anyone has a specific question, but I doubt it's something that will come up today. Also on slide 5, you'll see that healthcare providers who transmit certain transactions electronically are subject to HIPAA. This is what we're going to focus on for the next few slides. So slide 6. Are you a healthcare provider subject to HIPAA? Only healthcare providers who transmit individually identifiable health information electronically in connection with certain transactions must comply with HIPAA. What on earth does that mean? The transactions referred to in that sentence include claim transactions. For example, when your doctor submits a claim to your insurance company to get paid. Benefit eligibility inquiries. If you go to the hospital and they may send a request to your insurance company saying, is this person really covered by the plan? Referral authorization requests. You may have a doctor who wants to send you to a specialist and the doctor asks your insurance company, is this covered? is there a specific specialist we should go to? There are other transactions covered as well, but those are the major ones. Think transactions between providers and health plans regarding claims or payment for health care. So healthcare providers who conduct those types of transactions electronically are subject to HIPAA. Moving on to slide 7. Keep in mind that just using technology like email or an electronic database does not mean that a healthcare provider is subject to HIPAA. The electronic transmission of information must be in connection with those certain transactions that we just talked about. But also, if a healthcare provider, like a hospital or a physician group, hires a third party to conduct those transactions for them, the hospital or physician is still a healthcare provider subject to HIPAA. The typical example is a hospital hires a third-party billing service to send bills out to patients and health insurance companies and collects the money. The hospital itself doesn't conduct the transactions, but the billing service conducts the transactions on behalf of the hospital, so the hospital is a covered entity. Slide 8. As a general rule, if a healthcare provider transmits individually identifiable health information electronically to Medicare, Medicaid, or any other type of insurance company to get paid for the health care they provide, that healthcare provider is subject to HIPAA. I wanted to mention at this point that you'll see later on slide 21, I've included a link to the HHS website. There's a lot of helpful information on that website. For example, they have flowcharts that say, am I a covered entity? And you go through and answer questions, and it will lead you to yes or no with respect to whether or not you're a covered entity. They're not always perfectly clear, but they are very helpful. Slide number 9. As we talked about, because we keep using this term over and over, I just want to make sure we understand that entities that must comply with HIPAA are called covered entities. For the most part, hospitals and physicians that you deal with are covered entities. They transmit information to your health insurance company to get paid. One example that's come up with my work with Pro Bono Partnership is that free clinics are not covered entities. They do provide health care. They're a healthcare provider, but they don't transmit any information to a health insurance company to get paid. So they're not subject to HIPAA. And we have a question.
What about a mental health provider? Some of our nonprofits provide mental health services and may request reimbursement.
Yes, they are healthcare providers, whether it's mental health care or any other type of health care. They are healthcare providers. So the same question applies. Do they transmit the information electronically to get paid? Do they transmit the information electronically for reimbursement? Moving on to slide 10, we have another important term here, business associates. Any person or entity that provides a service to a covered entity and needs individually identifiable health information to provide that service is called a business associate in the HIPAA world. A member of a covered entity's workforce is not a business associate. So, for example, an employee of a physician group is not that physician group's business associate because they're a member of the workforce. The workforce includes employees and independent contractors, but can also include volunteers, for example. So you may have individuals who volunteer at a hospital. They're considered part of that hospital's workforce. They're not business associates. The reason we're focusing on business associates right now is because HIPAA has changed recently with respect to business associates. As of February 17th, 2010, business associates must also comply with most provisions of HIPAA. There are some parts of HIPAA with which business associates don't have to comply, but for the most part, business associates must comply with HIPAA like covered entities do. As you can imagine, what HHS is trying to address is the flow down of HIPAA requirements to the individuals that get individually identifiable health information. Typical examples of business associates, slide 11. We talked about billing companies a few minutes ago. Those are business associates, they need individually identifiable health information from their covered entity clients to provide their service. One really fun one is lawyers. When a lawyer works for a hospital or physician group, maybe they're helping defend a malpractice claim. If they need medical records to defend that malpractice claim, they get individually identifiable health information. They are business associates. They have to comply with HIPAA. As you can imagine, we've had a lot of fun with that one over the past year. You may have a software company that sold you some software but also maintains it periodically, maybe gets in your system to do some database maintenance work, and they have access to the information on a regular basis. Those are business associates. Covered entities and business associates must enter into specific types of agreements called business associate agreements. HIPAA specifies what must be included in these business associate agreements, so they are very specific and they are oftentimes difficult to comply with, but they are required by law. I definitely suggest if you're a business associate and someone hands you a business associate agreement to sign, call Pro Bono Partnership of Atlanta before you sign it because it requires you to do a lot of things. We had a few specific examples starting on page 12 that we want to talk about that may be helpful. An organization that provides interpreters to physicians and hospitals is not a covered entity. Think about the three categories of covered entities: health plans, healthcare clearinghouses, and healthcare providers who transmit claim information electronically. Interpreters do not fall into any of those categories. They are not a covered entity. The question, though, is the organization providing interpreters a business associate of a covered entity? And this is where it can go either way. In my practice, some hospitals have treated interpreters as part of their workforce, in which case the interpreters must comply with the hospital's HIPAA policies and procedures. They get trained on them. The hospital explains what they can and can't do with the information, but they're not a business associate. In other cases, the hospital has said, you're a business associate, you're not our employee, you have to sign this business associate agreement. That can go either way. And also, I wanted to mention, if you go to the HHS website, I provided a link on slide 21, there are some frequently asked questions, and if you type in the word interpreter, you'll get a lot more information on this question. We have a question?
What if you work with a covered entity
Yeah.
and you get information about a patient enough to be able to provide some kind of service to that patient, but that patient isn't paying for that service from you? You're just gathering enough information about them, either from the patient and or from the entity, to provide that service.
Yep, the question is whether you're getting the information about the patient to provide the service to the covered entity. In the example you mentioned, it sounds like you are, and so that entity would be a business associate.
Okay, but you're actually providing the service to the patient, not to the covered entity.
That does make a difference. The definition of business associate depends on providing services to or functions on behalf of the covered entity. So if a patient hires you to do something, that's a very different question. And that in itself, providing a service to a patient does not make you a business associate. On slide 13, we have another example. We've dealt with organizations that gather medical information from individuals, perhaps in the United States, perhaps all over the world, and then doctors volunteer to review that health information and provide free advice regarding their health conditions. Because there is no healthcare provider who is transmitting a claim electronically to get paid, that entity is not a covered entity. There is a question, of course, of whether the physicians themselves may already be covered entities because of their other employment situations. That's not really a question this organization that gathers the information can handle. It would depend on what the physician does elsewhere. If the physician practices in a group that transmits claim information to health insurance companies, the physicians may already themselves be covered entities, But like I said, it would be hard for this organization to know one way or the other. And also, the question of whether the organization is a business associate comes down to whether the organization is providing services to a covered entity. In this example, they're not. They're just volunteering to say, hey, if you want to send us your medical information, we have some doctors who will review it and give you some advice. There are no services being provided to a covered entity. On slide 14, I wanted to remind you that if you're not subject to HIPAA, and frankly, I hope you're not, it does not mean that other laws about the confidentiality of medical information don't apply to you. There are state laws requiring any licensed healthcare provider, like a doctor or nurse, to keep medical information confidential. There are also now state data breach laws, and if you collect personal information about patients, you may have to comply with those laws. Those are a very different topic from what we're talking about today, so if you need more information on that, you can contact Pro Bono Partnership. Slide 15. So what do you do if you go through this and you check out the information on the HHS website and you find out that you are a covered entity or a business associate? What on earth do you do to comply with HIPAA? I'll tell you, we can't really answer that question by the end of this webcast. Every covered entity or business associate's compliance is dependent on the facts of their specific situation, but we did want to give you some general advice. Generally, what HIPAA does, the HIPAA privacy rule governs the use and disclosure of the individually identifiable health information. For example, if you have patient information, when can you use it? Who can see it? When can you give it to a third party? When you're subject to HIPAA, you have to develop written policies, and that doesn't mean paper copy, that just means written down in paper or electronic form, that reflect all the HIPAA rules about the use and disclosure of individually identifiable health information. Slide 16. For example, covered entities and business associates must have policies about disclosing individually identifiable health information in these scenarios. When a patient requests the information, you get a phone call or a letter from a patient saying, I want a copy of my medical record, or I want you to send a copy of my medical record to another doctor. There are rules about when you can release it, when you can't, the time frame in which you have to release it. So you have to have a specific policy on how you handle those requests. In some cases, but not others, a covered entity or a business associate may disclose health information to a family member. It may be an emergency situation. It may be if a family member needs to help provide care to the patient when the patient is discharged from the hospital. There are very specific rules about when you can and can't disclose that information. You have to have a policy about that. In many, many cases, covered entities and business associates get subpoenas from a court or get subpoenas from an attorney saying, I want this record for a case, for a court case. If you get a court-ordered subpoena, you need to have a policy explaining how you respond to it, what information you can release and what information you can't. And for example, a court-ordered subpoena is different from an attorney-ordered subpoena, so your policies have to differentiate between the two. Some cases you may have a government agency. For example, HHS may have gotten a complaint from someone saying that you violated HIPAA. So they send you a letter saying there's a complaint lodged against you. Send us all your records about this patient. You have policies about what you can and can't send. As you can imagine, you can send a lot of information in that case. And in HIPAA, HIPAA is very specific that covered entities and business associates must still comply with state laws that require, for example, the reporting of child abuse or child neglect. So in those cases, you can use your individually identifiable health information to make those reports that you're required to make under state law.
I have a quick clarification.
Please.
HIPAA only applies to services provided to people receiving services in the U.S., correct?
I'm sorry, can you repeat the question?
HIPAA only applies to services provided to people in the United States, basically. I think it's the question.
Are the The question, I think, is whether
HIPAA applies.
is it a U.S.-based covered entity or business associate?
Well, no, not business associate, just basically the rules of HIPAA apply to people receiving services in the U.S. only? Or is it, outside of the country?
Right. I will say, generally, HIPAA would not apply outside the United States, but a covered entity that operates in the United States, there is no differentiation between information from patients from the United States and information from patients from other countries.
Okay.
Obviously, that's different from a doctor operating in another country.
But if that doctor works for a covered entity in
Right,
the U.S.
right.
It would apply.
Yep.
Okay.
Oh, no, I was just going to say that question gets pretty complicated pretty fast. And I don't think there's a quick yes or no answer to that question. I do want to say if you're a covered entity or business associate operating in the United States, no matter where the information comes from, I recommend being very careful with it. We'll move on to slide 17. These are more examples of what the HIPAA privacy rule requires. In addition to rules about when you can use and disclose the individually identifiable health information, you have to have rules about individuals' rights to access their own information. That is a very important aspect of the HIPAA privacy rule, in that the government tried to expand the rights of individuals to access their own information. Another requirement of the HIPAA privacy rule is that covered entities must provide patients a notice of privacy practices that describes how the covered entity can use and disclose the information. You've probably seen these when you've gone to the doctor. They probably asked you to sign something saying, yes, I've received a notice of privacy practices. They gave you a piece of paper that makes no sense, but they're required to do it. It's a notice of privacy practices. As I said, and I must reiterate, these are only a few examples of what HIPAA requires. So please don't take slides 16 and 17 and think that if you develop policies about these, you'll be covered. Unfortunately, there's a lot more. The HIPAA privacy provisions that we just talked about apply to all individually identifiable health information in any form, paper form, electronic, or even oral information. The HIPAA security rule that we talk about on slide 18 only applies to electronic information. And the HIPAA security rule requires covered entities and business associates to maintain the security, integrity of electronic individually identifiable health information. So if a covered entity or a business associate maintains any individually identifiable health information in electronic form, it must take certain security precautions. For example, and these are just a few examples, covered entities and business associates must develop a policy about access to electronic information. Who has access? What level of access do they have? It's inappropriate, for example, for a volunteer in the hospital gift shop to have the same level of access to the medical records as the physician in the hospital. When an employee of a covered entity leaves, who notifies whom to terminate the access? Who makes sure the access is terminated? What are the rules about passwords? How often do they have to be changed? Do they have to be a specific length? Obviously, sharing a password is prohibited. Another important HIPAA security requirement is audit trails, or log trails, as some people call them. If you're a covered entity or a business associate, you have to have a record of who accessed what information and when. A lot of software can do this electronically, but you can imagine, you've probably all seen cases in the news where hospitals had a breach of a patient's medical record, and they can go in and see this employee accessed this record on this date. That's a HIPAA security requirement. Slide 19, the breach notification rule. This is a new rule. It's only been in effect since 2009. If there is a breach of individually identifiable health information, that is, if there is any use or disclosure of the information that is not permitted by HIPAA, a covered entity must notify not only the patients involved, but the Department of Health and Human Services, And if the breach involves 500 or more individuals, you have to notify the media in your area. I also wanted to point out, as I mentioned earlier, that states also have very specific data breach notification laws. So complying with HIPAA's breach notification rule does not mean you do not have to comply with state data breach laws as well. As I mentioned, HIPAA has changed a lot lately. In 2009, Congress passed what's called the HITECH Act, which, for example, required business associates to comply with HIPAA, and that gave us the new breach notification rule. We are still waiting on HHS to issue regulations implementing the HITECH Act. We've seen some proposed regulations, but not final ones. Based on the proposed regulations, we don't anticipate that HHS is going to change the definition of a covered entity, but we do think it's possible that the rules about business associates may change. So if you're a business associate, be on the lookout for these new regulations. Slide 21, and I really hope this information is going to be helpful because you all have day jobs, you all can't keep up with HIPAA every day. It's a lot. So how can you learn more about it and keep up with the changes? I think the information provided on the HHS website is very helpful. So I included that link here. You can also sign up for HIPAA listservs on that HHS website. If you search the internet, you can find a lot of listservs about HIPAA from healthcare consultants. I encourage you to sign up for those. Law firms do a lot of legal alerts when new regulations are issued, so you could check periodically, check law firm websites, see if you can sign up for their newsletters, things like that to try to stay abreast of the changes. If you need any more information, on slide 22, we've provided contact information for Pro Bono Partnership of Atlanta, phone number, fax, and email address. And if there are any more questions, I'll be glad to answer them.